welcome, dear all, to this second session of the conference, and also to all of you present online attending this session. It is for me a real honor to chair what I'm sure will be a highly stimulating discussion on how to reconcile these logics of responsibility and solidarity, as the title of the session suggests. This is certainly one of the most decisive as well as contentious elements of the functioning of the common European asylum system. As you know, the recently adopted regulation on asylum and migration management seeks to provide a solution to this traditional imbalance between the responsibilities taken on the reception of asylum seekers and the examination of their protection claims on the one hand, and on the other, the manifestations and the provision of solidarity other member states should contribute with in order to ease that burden. And Regulation 2024-1351 establishes, most importantly for our purposes today, a mandatory but flexible solidarity mechanism made of national and diverse in nature contributions, while leaving almost unchanged the old Dublin rules on responsibility allocation. Of course, the questions these reform raise are infinite and from many different angles. I would just highlight a few of them. We could, of course, think of the most accurate meaning of the new old Dublin rules, which is certainly difficult to grasp, on the human rights compliance of these responsibility allocation rules, or their effects on secondary movements, on the impact of these rules when then combined with other regulations of the reform. Think of the screening regulation, for instance. Of course, we have questions about the practical and financial sustainability of the new solidarity mechanism and the operationalization itself of this mechanism, or whether indeed the AMMR itself and its implementation elements may lead even to an alteration of the competence distribution between the EU and member states, both regarding the normative executive powers or even affecting the national security competence of member states. As you know, it was recently raised by the annulment action brought by the French Assemblée Nationale on this argument. So there are many, many questions that this reform entail, and for their clarification, we are privileged to have here this morning the best specialists on the subject, distinguished and very admired colleagues who have worked a lot on these questions from the perspective of international and European law. And we have also the honor to welcome at this session representatives from 2 member states who are specifically well aware of the challenges that both responsibility and solidarity mean or should mean within the asylum policy. This is, as you know from the program, an hybrid session. So 2 commentators, Dr. Hornung and Professor Knoll, will be joining us online. So let's get started. Timing, as the organizers recalled, it must be strictly respected, so my apologies in advance for ensuring this working rule is applied. And thank you very much warmly to the speakers for their understanding. So let's start with our first speaker, Professor Constantin Hruschka. He is full professor of social law from the Protestant University of Applied Science in Germany, and he will talk about the Dublin system, the new or old Dublin system. So the floor is yours. Thank you very much.
So, thank you very much for the nice words, and thank you very much also for the invitation. And I will try to give you a glimpse of what is happening with Dublin, and I hope my presentation works. If it does not, I will be able to speak about it anyhow. So Dublin never dies, and that was the idea and the reason why this was brought up so prominently is because that we will keep the main rules for the allocation of responsibility. We are talking about solidarity later on, but these key rules are kept. And these key rules are also confirmed to be Dublin, because at the presentation of the pact and also at the presentation of the new, let's say, first reconciled package, Margrethe Schinas said, it's Dublin, but smarter. And I looked at it and thought like, okay, that's project management. It should be specific, measurable, attractive, realistic, and time-bound. And then, so we look at the elements, it's specific. It's a common framework, integrated policymaking, comprehensive mechanism, efficient mechanisms. So you see, I don't think that's very specific, so we will have to look into this a bit more. Measurable. The measurable part is we have to reduce unauthorized movements. That is what is recurring in that proposal. We heard this already from Daniel as well. And better informing asylum seekers' rights and obligations, a better judicial remedy by limiting the scope and calling it specifying the scope. So you can also measure that. But I think apart from unauthorized movements, and we heard that we don't have figures, measurability is also not very clear. As Dublin hasn't changed, I have to refer to Steve Pearce, and he called the second phase instruments lipstick on a pig, and only for the Dublin regulation part, it is more lipstick on the pig. It's very clear, and if you find that attractive, that's for you to choose. If you look at the goals, and I only took a part of the objectives here, I think it's also not very realistic that we will see a big change. And then we go to time bound, and that's a bit difficult because Dublin is not a project. But if you look at it, it didn't deliver. That's why we keep it. So I don't know what to say about this, but I will, of course, come to some more legal points to the AMMR. What the first observation on this is, how will actually Dublin fit into screening and the border procedure and the reception conditions directive? Because what will be the role of Dublin? You cannot tell, because if you listen to all the presenters, you will see that basically everything will be done at the external border. So we don't need Dublin anymore because nobody will be in this procedure. Of course, we know that this is nonsense because most of the applications are still made inland, also with all the border controls. But so there will be a role for Dublin, but it doesn't fit between the screening regulation and the asylum procedures regulation. So that's for the implementation to see. And what is green here are the survivors, the unchanged survivors. For the returns directive, we know from the letter from the president of the commission that this will also change, but we will have to change the Dublin implementation regulation. Otherwise, there will be no change. And it's not changed yet, so I cannot say something about the practical issues here, or the legal issues related to the practical cooperation, to be more precise. And then we will really look at allocating responsibility in the regular procedure, because the rest will be done by Francesco Maiani, and I will obviously not talk about this. And so now we can go into what has changed and what didn't change. What has changed is basically the implementation of obligations for the asylum seekers to stay in the first country of arrival, to put to lodge their asylum application there. And this is one of the key elements where sanctions are also put forward. You look at Article 16, that has not changed. The member states still have to look at every asylum application that was lodged, and that didn't change. But then you have obligations for applicants and you have sanctions. And this sanction is already very interesting because it excludes asylum applicants from the reception conditions directive, But it basically says, but you have to keep up fundamental rights. And if you look, for example, at Germany, a country that was cited several times already today, the German Asylum Seekers Benefits Act basically says they get the pure minimum during the procedure. And now look at the sanctions in the Dublin procedure. How do you get below the pure minimum? So I don't think, and I know that in a lot of other member states, it's the same. So the question is, what will this sanction actually be? Can you go below the defined minimum? And I'm not so sure that this will work from a legal perspective. Of course, from a practical perspective, there will be an incentive to give less reception conditions to applicants that are not in the right state. And the right state is also defined in Article 17. But whether this will work on a human rights basis in the system, I'm not so sure, but it will be work for lawyers. Then we can look at other changes. Elements of proof, for example, can only be submitted until the decision is clear. But we also have, apart from the obligations, extended guarantees for asylum seekers, better information, accessible information. There are more rules on that. Free legal information is strengthened, and also the personal interview. It has not changed much, but it's also better than before, and Article 5 of the Dublin III regulation was already a very good legal guarantee. One of the main changes is that unaccompanied minors are to be Dublined as well. But let's say there is a slight tension between Article 25 and Article 23, because Article 23 that contains the guarantees for minors basically says you can only transfer minors if it's in their interest, in their best interest. And Article 25(5) basically says you can transfer minors if you don't have family members. And the question is, how do you do that? And you will see, we will come to the legal remedies, that this is also not very clear. It leaves, from my perspective, the space open for member states who take the protection of minors seriously not to transfer under Dublin. It's not obligatory because there is this tension between Article 23 and Article 25, but it also leaves the possibility for member states to transfer unaccompanied minors under Dublin. So it's unclear, and of course, coming from a basically human rights perspective, I think it should be read as you cannot transfer minors if it's not in their best interest. Then we have the family criteria. You see there's nothing blue, it has not changed. Only, and it should have been blue, long-term residents are included in the definition of legally residing family members that incite responsibility. And with the other responsibility criteria, we have three major changes. One is the new criterion on diploma and qualifications that lasts for 6 years. And then we have the new criterion that is called entry in Article 33. And it basically contains irregular entry, entry after a search and rescue operation, and it contains relocations under the solidarity system. And so I've put it in order how they would be applied. And the relocation, even though it's in para 3 of Article 33, would be first, because if a person is relocated to a specific member state, this member state will remain responsible regardless of what is happening. For the sovereignty clause and the humanitarian clause, there are not many changes. Also for the transfer of responsibility, time limits are a bit extended, and we have a new time limit of 15 months after the rejection in a border procedure. What does that mean? The person is in a border procedure, is not removed, but has a negative decision, then the member state that has conducted the border procedure will remain responsible for 15 months. And after that, it's not responsible anymore. It's the time limit for absence is increased from 3 to 9 months. And there's also the transfer of responsibility is contingent on the results of the best interest determination. This is what I alluded to before, so that it's possible not to transfer unaccompanied minors or even accompanied minors. Then we have new shortened time limits for take charge requests, and we have no take back request anymore. It's a take back notification. And then we have detailed rules on time limits and transfers, and I will only want to show you that there is a time limit of 3.5 years. If the person is sick, if the person has absconded, because it basically says here, I don't know whether that works. No, it doesn't. It says up to a maximum of 3 years from when the requesting member state informed the member state responsible that the person concerned or a family member absconded, physically resisted the transfer, intentionally making him or herself unfit for transfer, or not complying with the medical requirements. So it's after the 6 months, then you notify, or within the 6 months, and then it goes 3 years. So it's basically 3.5 years and not 18 months anymore. And of course, this will be, this is in tension with the CJEU rulings on the speedy Dublin procedure being a decisive part of the common European asylum system. And then last point, we're looking at remedies. And there is, of course, the right to an effective legal remedy, but it's now specified in content. And the specification is a violation of Article 4 of the Charter. That's very clear. And also family issues. If you look at 25 to 34, here under C, that's the family issues. And then we have this wonderful thing, whether there are circumstances subsequent to transfer decision that are decisive for the correct application of the circulation. This means, if you translate it, you cannot ask for the correct application of the criteria anymore, but it means you can still apply you still have a judicial remedy against elapsing time limits, because that's after the transfer decision. And so there will be a lot of judgment by the CJEU on that, because a lot of member states don't want enforceable time limits, and they put this there to have a discussion basis. Ending with the pessimistic view, that is how Dublin procedures will look like. That is how reception conditions will look like. And of course, positively, it will look like that. It's very organized. To me, the main conclusion on what is actually happening with Dublin is there's not many changes. There are some very restrictive elements to the new proposal, but not that many. But it didn't work before. So for me, we have a big problem, and I'm coming back to project management. It's badly written, it's amorphous, it's non-innovative, it's administratively unworkable, and it remains lopsided. And thank you very much for your attention.
Thank you so much. I was indeed highly stimulated, and playing with words is always for that purpose. So not many changes, but some new restrictive elements. So I think we have also questions in our minds to ask you about how they intended the system to work and to end with the deficiencies that we were pointing out in the first session. No, so let's go that for the time of the Q&A questions, the Q&A timing later. Sorry. So now, do we have the comments or no? So, yeah? Okay, great. So we have the privilege to have Dr. Ulrike Hornung with us online.
Yes, hello. I hope you can see and me?
And no, I cannot see you yet, but probably it will come. Yeah.
Yeah.
I don't know if the camera is turned on.
So my camera is on. I can see myself on the screen, but that doesn't help for the audience.
So
I can also see as a participant online.
Yeah, we cannot see it in the screen. I don't know if I wouldn't like to start without introducing. Yeah, great. Thank you. So we are, as I said, very honored to welcome Dr. Ulrike Hornung, head of the Directorate on Migration, Refugees and European Harmonization from the Federal Ministry of the Interior in Germany. So please, the floor is yours for your comments on this report.
Yes, thank you very much. And in fact,